Should you ever consider co-signing a mortgage or becoming a guarantor for a mortgage? Now, this video is going to overlap somewhat between money and law. For those of you not familiar with my other channel, it's Black Belt Barrister, where I help you to understand law. On this channel, I'm helping you to build wealth. So helping you to build wealth, it's necessary also sometimes to help you to avoid losing everything. That's right, you could potentially lose everything if you co-sign a mortgage. Now, not wanting to wear both hats at the same time, this is going to overlap somewhat partly because I can't help talking about the law sometimes, but also the issues involved. Whilst it is a question of money and circumstance and family and need and necessity and everything else, there is a legal aspect to it, which I'm going to explain in this video. So to one extent, whilst you can't rely on this video as legal advice, this video will contain near enough what would be the legal advice that you would be required to take if you wanted to co-sign a mortgage. Why is that? Well, let's talk about what it is, and this will become clear. When you are asked to co-sign a mortgage, whether that be with a significant other or a sibling or one of your children, or worse still, just a friend. I say worse still for reasons I will come back to, and ultimately the reason you need to take formal legal advice before you're allowed to do this. Now, these situations are usually coming about where one person or two people other than you are going to own the property. They will be the proprietor or the proprietors, and you are being asked to co-sign the mortgage or guarantee the mortgage by way of agreeing contractually that you will make up the payments if the proprietor, whoever owns the property, doesn't keep up with those payments. This is often referred to as a joint borrower, sole proprietor arrangement. Now, this is obviously where you do not own the property. You have no legal interest in the property, meaning if anything goes wrong, you can't sell it in order to make good the debt on the payments, but you are still liable to those payments. Now, when you go into one of these arrangements, the bank or the building society or whoever is likely to require you to confirm in writing and sign to say that you have received formal legal advice on this arrangement. And in doing so, many people that do that, and many people that have come to us, and I have sat down with to go through this advice with them, have been quite surprised as to the extent of the information and the extent of the risks that I've highlighted in doing so. So on this channel, as I said, I'm helping you to build wealth. On Black Belt Barrister, I help you to understand law. And I'd like you to subscribe to both. I've kept them separate because to me they are really separate topics, so I'd like to talk about them separately. Many people use the same channel. I'm hoping at the moment at least to keep them separate. So let me know in the comments what you think. Separate channel or the same channel? Let me know your thoughts on that. The jury's out, no pun intended. So if you were to come to someone like me for formal legal advice based on signing as a guarantor or co-signing, whatever you want to call it, the mortgage, effectively guaranteeing those mortgage payments for somebody else that is going to own the property, then we would go through with you the full scenario and set out the background as to what's happened. The typical scenario is mum and dad have a son or daughter who has a boyfriend or girlfriend or fiance, or even they've already got married and they want to buy this property, but they don't quite meet the lender's criteria for affordability on that mortgage. Now, this is not going to strain to mortgage advice, and it's not to be taken as formal legal advice. This is an overview of the things that you would need to consider in that situation. So if you were going for that formal legal advice, this is what most of it would entail, and you can decide whether or not you still want to go for formal legal advice or not, but this is an overview of that process. So we would then sit down and discuss with you, right, what's the situation? How has this come about? You would tell us the value of the property that's going to be bought, what the affordability is, whether your son, daughter, boyfriend, girlfriend, fiance, husband, wife, whatever, whether they can really afford those payments, as in quite literally, do they have the budget to make those payments? and why it is that the lender is asking you to co-sign the mortgage. It may just be that they want that underpinning assurance that someone else is there to pick up the mortgage payments if in the event that these fall short. Now, in doing so, having set out that situation, if it was abundantly clear that this was a huge risk to you, that would be one of the flags at the outset of the advice. An advice like this would typically be confirmed in writing because the bank would ask you to sign to confirm that you've taken advice. So usually it would be better to have it in writing so it's complete, it's coherent, you can refer back to it, and you can always have it to hand. Now, some of the salient points to note on a situation like this are that each party to a mortgage, which would include you even if you don't own the property, you'll still be party to the mortgage, will be jointly and severally liable to the full loan amount and the monthly payments. So regardless whether you own any interest in the property at all, if you are signing the mortgage, you are responsible both by yourself and or together with everybody else that's signing the mortgage for the full loan amount. So what that means in straightforward language is if there are 3 of you on the mortgage and 2 of them just can't meet the payments anymore, let's say son and his girlfriend no longer have their job, they've lost their job, but they're still in the house, so they can't make the mortgage payments at all. Maybe they go on to some form of benefits, but they just can't make the mortgage payments. You are left as responsible for those mortgage payments, but they still own the house and they are still living in the house. There are certain remedies that you can go to later on, but that is not without difficulty. The starting point, the most salient point is you will be responsible for the full loan amount and the monthly repayments. That means, quite simply, the mortgage company can come to you for all of the mortgage payments, all of the interest, for the full duration of the entire mortgage, which might be 20 years. So if you are looking to retire in 5 or 10 years, then if anything like this happens, you will be on the hook for that mortgage for the full mortgage term. This is regardless of whether your son or daughter and whoever picks up another job and is therefore then able to pay the mortgage payments again. You are liable to that mortgage for the full term. Now, not only do you have to look at the full term, but you should also look at any fixed periods. For example, most mortgages obviously have a fixed rate at the beginning, although in certain points of market volatility, these lenders are not offering fixed rates and only offering their variable rates. But nonetheless, if there is an initial fixed rate introductory period, you need to consider what the variable terms are going to be after that period, because you'll need to make up those payments as well. The second and natural follow-on progression from that is if there are missed mortgage payments, not only is the lender going to go after the primary borrower to that mortgage, but they are also going to go after you. Now, that obviously means a trip to the county court if you can't pay it and they sue you for the money. That would be for any monetary amount that is outstanding, and they may still go for possession. And the potential problems that arise are not limited to money. Because, as I said, a very common scenario is when son or daughter has a boyfriend or girlfriend, or they even get married and then buy the house. And very often serious issues arise in the event that they separate. On the one hand, if they are married, then you have the whole matrimonial assets discussion to have, and whether there was any gifted deposit, because banks like it to be a true gift and no expectation upon it being returned. And so that will usually become matrimonial property unless there's an argument that it was unequal contribution, and all of those kind of arguments are had in court. On the other hand, if they are not married, then the usual default position is going to be that they will jointly own the property in the absence of any deed of trust to the contrary, and any dispute about the same will be resolved under the Talata legislation, that is, Trusts of Land and Appointment of Trustees Act of 1996. And the starting point here is that each party will own 50% of the property unless the court orders otherwise, and there's a whole list of criteria that the court goes through to decide that. But all while this goes on, you will still be liable to those mortgage payments if you have co-signed the mortgage. There are also some peripheral issues such as insurance. Mortgage companies usually require that the property is insured at all material times, and so in the event that there's a real fallout and the property lies abandoned, you will be responsible for insuring that property and, to some extent, making sure that it's not left vacant for any certain period of time. Because one of your mortgage terms might be that the property is not left vacant. And even if that term is not there, if the term is there that it's got to be insured and you won't get insurance if it's vacant, then someone is going to need to live in that property. Another issue is that you're not likely to be able to be removed from the mortgage without the mortgage company's consent, which they're not likely to do if that's one of the conditions of approving the mortgage in the first place. So ultimately, it comes down to a list of things that you are going to have to declare to the mortgage company that you, as the guarantor, the person co-signing the mortgage, is going to have to declare. These will include, of course, that you've read and understood and agree with the terms and conditions of the mortgage, that you understand and recognize the risks of being involved and being a party to the mortgage under this sort of arrangement, where it's a joint borrower, single proprietor. Also, of course, that you are familiar with the interest rates, the fact the interest rates might change, that you are able and you can afford to repay all of the facility provided under the mortgage account, that you've got the appropriate means to do so, and that if you fail to make those payments, that they may obtain a judgment against you and even go so far as to applying for your bankruptcy in the event that you don't make the payments. All of this means that you are signing to confirm that you've taken formal legal advice and understand that you are putting the lender's interests ahead of your own in virtually every sense possible, unless and until the mortgage has been paid in full. So whilst of course none of my video can be taken as either financial or legal advice, if someone were to ask my general guidance as to whether or not you should co-sign a mortgage, my general guidance would be no. In most cases, you should probably not. Because ultimately, nobody can really predict the future. Nobody can really predict what's going to happen. If you have a son or daughter that has a boyfriend or girlfriend and they want to buy a house and they can only get it with you co-signing the mortgage, then if all of that just goes horribly wrong, you will be left with a mortgage for a house that you don't own. That is not a great proposition for anybody to be in. But I do understand that many parents are in the position of their children having to get a house and having to get on the property ladder. What would I recommend in that situation? This is one that is often met with a lot of pushback. The only real recommendation that I can make is that you are at the very least one of the joint proprietors. The mortgage company is not really likely to object to you being one of the proprietors if you are guaranteeing or co-signing the mortgage, but at least if there is a huge fallout further down the line, you are one of the proprietors of the property. At least then you have a standing, if necessary, to go to court to ask for an order for sale. Now, even that isn't a straightforward walk in the park. I've been back and forth to court many times for clients for and against an order for sale. And there's a list of criteria that the court will consider. Who's living in the property? Are there children in the property? What is the likelihood of someone displaced from the property being able to obtain alternative residence? And in the event that there are children there and it's impossible for them to find somewhere else to live, the court might find it difficult to rule in your favor. But at least you will be a proprietor of the property. And on paper, it's still an asset that you own. So coming full circle, many people seem to think that this is just a form-filling exercise, one of the tick boxes required by the bank in order to approve the mortgage. But as you've hopefully found out in this video, it's not quite that straightforward. But I hope you found it interesting. I hope you found it useful. But if you really want to help me out, please do subscribe and, most importantly, watch one of these videos here. That helps YouTube to extend the session time so that it knows you enjoy my content. And in the meantime, thank you for watching.